When someone comes to you and says, go after the criminal, right? Why are you going after the hotel? What do you say?
That's a great question. And one of the reasons is because, you know what? If we sue this criminal, he or she won't do it again. If we sue the hotel, they may stop this from happening 10 times or 20 times or 30 times. A lot of what we want to do is make the world better and safer. And if I can sting a hotel or an apartment complex or a mall or a restaurant once, maybe they'll increase security and make sure this won't happen again.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we have the privilege of having Peter Everett and Barkley Horn from Blankenship and Keith up in Northern Virginia join us. Guys, I'm really excited to have you both. I remember, Peter, you and I first met. I took on a nearly impossible negligent security case, posted about it on the listserv, asking for some guidance, and you gave me the wise counsel of saying, hey, maybe pass on this one and wait for a better one, considering, one, how difficult of a case it was, and then also just Virginia law is just not great when we're talking about these types of cases. And so, Pete, you and I have maintained contact since then, and I'm still waiting for the day where I get to work with you on something. And now Barkley, I didn't know Barkley at first, but I'm big on LinkedIn, and Barkley leads the firm's kickball team, which I am partial to kickball. So huge kickball fan. And so, but in addition to that, Barkley has the privilege of working with such great lawyers, to include Pete, Blankenship, and Keith. And they both do some really incredible work and have a very interesting practice area. It was different from your run-of-the-mill kind of personal injury shop. So guys, really great to have you both. If you wouldn't mind, Pete, starting off and introducing yourself, that'd be great.
More than happy to. So I'm Pete Everett. I've been a trial lawyer for close to 40 years, but I came at this in an unusual path. I started off, I think, Sharif, you'll love this. I was a private investigator. I was an actual PI, a gumshoe, and I worked in that capacity before going to law school and did some work for one of the best trial lawyers in Northern Virginia, a guy named Bob Arthur, who was my mentor. Then I took a bizarre detour. I went to the University of Virginia and then joined a corporate law firm for 5 years. And I've been doing penance for that for the last 35 years. And so I work today because I just thoroughly love what I do. I love our clients. I love helping people. And we've kind of evolved a little bit in how we help people. I could talk more about that later. But I'm going to let Barkley introduce herself.
Yeah, I'm Barkley Horn. I've been at Blankenship and Keith for 3 years. It'll be 3 years in October. So I've been practicing law for 3 years. I'm originally from Kansas City, Missouri. Big Chiefs fan. And I had the privilege of growing up around personal injury law. My dad's a personal injury attorney in Kansas City. 2 of my uncles are personal injury attorneys as well. And I just watched my dad love this practice, and I went to college from KC. I came out to DC, went to college, and knew I was going to go to law school. Had that interest and love for plaintiff's work because of watching my dad throughout growing up. And I kind of decided that's what I would do if I continue to still like it. And that was the case through law school. And I got very lucky in finding Pete Everett and the partners here at Blankenship and Keith and the personal injury group. So I've been with them since I was a summer associate. I did clerk for a year on the Court of Appeals before I came and practiced law, but so far, so good.
It's awesome. Well, before we get into the serious stuff, I do have a couple questions. So Barkley, I actually lived in Lawrence, Kansas for a little bit while I was clerking for a judge on the 10th Circuit. And I remember, of course, doing the touristy thing and trying all the different barbecue spots. Do you have a favorite?
Yeah, I always take people to Gates Barbecue. Now, I'd say that's where I take people, but I think there's a few others, Joe's in particular, which probably compete with that. But yeah, I mean, I just took a group of friends home to Kansas City this summer, and of course, you got to take them to barbecue. You got to try to get them to Arrowhead for something. And other than that, it's like lake culture in the Midwest. So it was a really fun place to grow up, and I go back quite often.
I tell you, the one thing I didn't expect before we moved there was how hot it got in the summer. Like that, I mean, I had done some time at Fort Stewart and outside of Savannah, Georgia, and I thought that was as hot as it could get, but I could have sworn that the Kansas City area rivaled that for sure.
Oh, yeah. I mean, humid, hot, all of it, for sure.
Well, cool. Well, let's talk about your practice, right? So you guys are not the standard personal injury law firm, right? You all get into some very, very interesting work. Would you guys mind chatting about that a little bit?
Yeah, I can start. So first and foremost, we represent survivors of violent crimes, particularly, unfortunately, in a niche practice where we represent children who've been sexually assaulted in childcare centers. And these are just heartbreaking cases. You see the lifetime effects. One of the things that we want to make sure we do is work with the absolute best forensic experts who can talk about, unfortunately, the impact of these children. Secondly, stepping back a little bit, we represent other victims of sexual violence, typically by employees, committed by employees of hotels, restaurants, colleges, churches, and other organizations. And this is the key, who use their superior position to assault employees or parishioners or customers. It's all about power and power differential in these cases. Third, we do real high stakes motor vehicle crashes. Unfortunately, we represent families who lose loved ones to reckless truck drivers, drunk drivers, and others, or the clients survive, but they face a lifetime of mental and physical harm. And we try to help them on their journey in that regard. I guess the fourth area is and this is really unusual, we represent victims of dangerous conditions on land and in buildings or roadways, not your basic trip fall cases. These are unique and interesting premises liability cases. For example, several recent cases involving dangerous construction sites. One currently now set for trial in which someone dropped a crowbar from 100 feet above where this guy was working, and it caused his death. And he was this amazing dad, a father of 4 children, and he leaves his wife just inconsolable and his children deeply grieving. We've spent days, including Barkley, meeting with and developing bonds with his 7 children and filming the clients for 2 different documentaries. So we have a particular focus on wrongful death cases and traumatic brain injury.
What drew me to this firm initially, I kind of told you before we started the podcast that growing up around personal injury, I looked specifically for, I think I was Googling, best personal injury firms in Northern Virginia, something like that, in law school, trying to find great people who I could work for. Because my parents always told me, go find some great lawyer and make yourself indispensable to them. So I found Blankenship and Keith. I found Pete and Rob and the whole team here. And what stood out to me was the creative sort of cases that they did. So I think at the time that I was looking at, there were cases involving, parking garage, inadequate security type cases, apartment assaults that happened in apartments. That really stood out to me, especially as someone who had moved from the suburbs to the city and was kind of experiencing all these sorts of things myself, and hyper aware of them at the time. So I love our creativity of our practice group. I love that we'll take on new types of cases, and our practice is always evolving. But I mean, Pete covered it with kind of those main areas of our practice.
I remember the first time Pete and I spoke and I was getting his guidance on this wrongful death, negligent security case. I remember him saying, Sharif, you went to UVA, you don't want to just do car wreck cases. Not that we don't, I love car wreck cases, happy to help whoever, but you want to get into some of these more interesting things. And then Pete, to your credit, you recommended that I look into the National Crime Victims Bar Association, and it's opened my eyes big time to the different opportunities there are to really help victims and crime victims. I've been to their mid-year conference. We're going to their conference here in Florida in September, and it's a practice area that, frankly, I don't think I realized existed when I was in law school. And I'm blown away that it does, in fact, exist, because it just shows you how much wrongdoing there is out there, especially with the cases that you guys handle, like the betrayal of trust with institutions, where when it comes to, I don't know, your massage parlor or your daycare or your medical facility, all that, where we expect these institutions to do right, to adhere to a certain standard of care, and they don't. Right. And so anyways, your conversation with me really helped me find this world, and I truly enjoy it. It's very meaningful work. So Barkley, I completely get it when I hear you say how lucky you feel to be a part of this crew. Well, enough of me talking about how good you guys are. Now I'm in the back of my mind, I'm curious. I'm like, well, how do you even get these cases? Like, Pete, how did this practice develop?
That's a really interesting question. Way back when I had a senior partner, I was a young associate, and we were a much smaller firm, Sharif. And so we got this story. It's actually a great question. We had this amazing case involving this woman who had been walking through a parking garage, and she was attacked by a gang of girls with a baseball bat, bludgeoned and left terribly brain injured. And it was against a huge mall, one of the largest in the world, called Tyson's Corner Center in McLean, Virginia. And I didn't know, Sharif, I didn't know what I was doing. I took this case, I researched the law, and I figured, well, I think I can make this case work based on certain facts. And the facts are, we had to show that there was a significant amount of crime at the mall and that they weren't doing much about it. And so through a combination of discovery to the mall and from the police department, we amassed this remarkable portfolio, if you will, of crimes at this major mall that everybody thought was safe. And so we sued Tyson's in federal court. We beat a demurra. The judge was Albert Bryan, who was a famous judge back then. And as a result of that, we were headed to trial. And I'll never forget going down to the Eastern District for a settlement conference and hearing our case on the radio as the Christmas shopping season was about to unfold. So we resolved the case, and then the Washington Post quoted me on the amount of crime at Tyson's Corner Center. Very straightforward, very factually oriented. The next thing you know, I'm so glad you asked me this, Tyson's files a motion in federal court to gag me from talking about crime at their pretty little mall, so that parents wouldn't know when they were dropping their 12-year-old daughters off there that there were sexual assaults or there was violent crime permeating the mall. And as a result of that, it went to a federal judge, and she basically made short shrift of this. But the Post did another article on the fact that they tried to gag me. Well, the next thing you know, I was flying out to Chicago. I was on Oprah Winfrey. I was on a number of TV, Larry King Live, which was back then was a big show. So that sort of launched my career, was Tyson's, ability to throw gas on the fire, if you will.
You know what's funny about that is, like, I've found that whenever you see a big verdict, oftentimes it's because the defense has helped you get there, right? And like I can see, like, they make the stupid arguments, right? They take the unreasonable positions. And in this situation, instead of just letting it be, the gas on the fire is what probably led to a better result for your client, right? I mean,
absolutely. I mean, we had another case like that. I don't want to bore you with it, but it led to the biggest verdict in the history of Fairfax, biggest products verdict at that time in Virginia. We represented a little boy who had really terribly sad. He was 13 months old. He was trying to touch a window screen just to feel it. His dad was right with him. This window screen popped out. He fell and was terribly brain injured. And we took that case against the screen manufacturer as well as some other defendants. We went to trial, and the trial was a hung jury. And so we then dug and found the smoking gun, Sharif, that you will find in virtually every case. We found an employee who worked in the shop where the screens were made. He was coincidentally been the fire chief of the small town, the police chief of the small town. So his credibility was unassailable. He testified that they found out that the screens were being defectively made so that they would pop out. They wouldn't hold at all. This kid didn't hit it. He just touched it, and out he went. He testified in a video deposition. The trial judge, who was an insurance defense lawyer, started ruling against us in the trial because he knew we were going to win. After that, it was blow your mind type testimony, and it showed that the screen company just didn't care. The words were ship them out, ship the screens out. So we tried that case the second time and got a $15 million verdict. However, back then, the Supreme Court of Virginia was ultra conservative, pro-business, and they took the entire verdict away. We had settlements with some other defendants, but it was a very kind of tragic end to a case. But it makes your point about how bad facts and really bad actions by the defendant really increased the verdict range.
No, absolutely. Well, I want to talk and ask you guys a little bit about how you guys work up cases in your firm. But before that, the question that I've got kind of nagging in the back of my head is like foreseeability. When it comes to these types of cases that you all deal with on a day-to-day basis, your negligent security cases, for example, like the case you talked about at the Tyson's Mall, the sticking point that I have always run into these types of cases is, all right, well, to what degree do you have to actually prove that it was foreseeable? Like I've read and I've discovered that sometimes crime statistics alone aren't enough, right? So what is, because I imagine this is a frequent issue that's coming up in some of the cases that you guys take.
It is. So for a while, Sharif, I was like the marauder of the malls, okay? So we had another case against a mall that will answer your question. First of all, for those who are not in Virginia, folks need to appreciate what Sharif just said, which is that Virginia law is very different from most states. In most states, or many states, there's a totality of the circumstances rule for foreseeability, right? So if there have been enough bad things happening, and some of those can include property crimes, not just personal injury crimes or violent crimes, then you can establish foreseeability. In Virginia, you can't even do it in large part with prior crimes. You need to show that in general, a business, that their method of doing business attracts criminally assaultive behavior. That's a pretty tough threshold to hit, or that there was an imminent probability of harm, so that the mall in this case or another institution really knew it was about to happen. Well, we, believe it or not, I won't tell you the name of the defendant. We had a mall case in which the mall was told by the police that there was an undercover gun operation, sales operation at the mall, and the mall did nothing about it. In fact, what happened was gangs were coming in droves to the mall. And in that case, that was actually enough to defeat summary judgment. And we settled that case right on the heels, basically, of trial. So it's that kind of level. Another example, Sharif, is that, and this is in the Skate America case from the Virginia Supreme Court, you probably have seen that. If you've got a situation where somebody had been banned, a bad guy, banned from a premises because of violent actions, and they come back, then you have a good case on foreseeability. But it is tough. It's a tough threshold.
And we get cases, I get calls with these types of cases all the time, and it's just, it's difficult, right? I mean, it can be very difficult. And do you have any sense as to why Virginia is as strict as it is when it comes to these cases? I mean, I do understand the argument of like, well, it's the criminal is the one who's really at fault, and we're not putting the blame on the third party. But then I think the counter is often, well, I mean, the third party allowed for the opportunity, right? And so that's why anyways, what are your thoughts on that?
Well, I mean, I think you're right. I mean, the Supreme Court has this sort of really ancient belief that you can't predict crime, which is frankly completely false. That's why people have crime statisticians to figure out, where hotspots are, for example. But it's the idea that you can't stop crime, can't know what's going to happen. What are you going to do about it? They kind of throw up their hands. Now, I will say in Virginia, there's one major exception, that is hotels. The Supreme Court has carved that out in common carriers and said in those cases, then there is an opportunity to show that there was foreseeability and that therefore there is a duty to protect patrons. And Barkley, maybe you could, without naming the hotel, maybe you could talk a little bit about a hotel case we're working on right now to illustrate that foreseeability.
We have a case right now involving a woman who worked at a restaurant, and someone who worked with her at the restaurant transported her essentially from the restaurant to a hotel after a night of partying or while on the job partying. And we know that she was brought into the hotel while she was intoxicated, visibly intoxicated, and that the front desk person at the hotel, watch this happen. And what we're exploring now in the case, is whether this hotel had notice of prior incidents like this, whether this person had done this before. You're right that we need concrete evidence of some sort of similar criminal acts. But, when you have a front desk person like hotels often do standing there at the front, and then you have someone who is in fact now, like Pete said, a guest at the hotel that evening, we believe that those are at least good facts for now as we start our investigation.
I mean, essentially, this woman's boss, who's 20 years her senior, plied her with liquor. She was like 21, 22 years old. Got her and others drunk, tried to assault her earlier in the restaurant. I would say essentially kidnapped her, took her to this hotel 10 miles away, driving past all these other hotels. She is literally almost unable to stand. And he escorts her right through the vision of the front desk clerk and then takes her to a room and sexually assaults her. So I think there's a pretty good argument that there was a duty on the part of the hotel operator when they can see that a person who is really cannot care for herself is being walked right through the hotel lobby.
When someone comes to you and says, or makes that argument I mentioned earlier about, go after the criminal, right? Why are you going after the hotel? What do you say?
That's a great question. And one of the reasons is because, you know what? If we sue this criminal, he or she won't do it again. If we sue the hotel, they may stop this from happening 10 times or 20 times or 30 times. A lot of what we want to do is make the world better and safer. And if I can sting a hotel or an apartment complex or a mall or a restaurant once, maybe they'll increase security and make sure this won't happen again. Or maybe they'll do, there's a lot of cases that don't involve stranger to stranger crime, Sharif. So in the case that Barkley mentioned, we're suing the restaurant. And the completely different set of rules apply in Virginia, as you well know, called respondeat superior, which is if a perpetrator was essentially otherwise on the job when he or she commits a crime, then their employer may be liable. And so we're seeing that in that case really turn out pretty well, we think.
That's a really interesting issue. I've been fortunate enough to get to work on a handful of cases where that comes into play. And there's always almost like a fine line, because if the act is too intentional, then the argument I found from the defense is, well, this wasn't in the scope, right? And so, which it's almost like it's got to be just walk that fine line. But there is a good jury instruction in Virginia that, if I remember correctly, there's an element or a factor to consider that says, like, well, if it happens in the course of employment and it's a result of some natural impulse or something like that, it's still covered. But yeah, what you said about deterrence is the reason why I enjoy this work. And I think, and I agree with you, it's why going after these cases are righteous and should be done more, because the reality is, if we're working to put ourselves out of a job, that doesn't seem likely, unfortunately, but that's really the goal. And frankly, I think that's kind of what our clients want more than anything. I mean, it's rare that I have a client call up and say, yeah, I just want to make a ton of money. In fact, I don't think I've ever had that. This Absolutely. Shouldn't have happened. We want accountability, and I don't want this to happen to somebody else.
One of the things that we strive to do in the right case, if we can, we should do it more, frankly, It's to see if we can get non-economic reforms done,
Right.
by the defendant. So we were fortunate to work with a great lawyer. You probably know him, Doug Fearberg, in the National Crime Victim Bar Association, as well as Elliot Buckner in Richmond, on a case against VCU in which there was a brutal hazing of a young man during the pandemic when people were desperate for social interaction. He rushed a fraternity. They got him liquored up. It kind of hit him from nowhere a little bit, and he died. I mean, it's a horrible situation. So we didn't file a lawsuit. We filed a claim against VCU and resolved it with them, but also got them to change the way they regulate new student organizations, not even just fraternities, which was great. Then we went after the national fraternity, resolved it with them, and they agreed to pretty significant reforms, again, in how they would bring new members in, whether regarding alcohol or a number of other factors. And they have 100 chapters across the country. So we feel like our case can make, multiply 100 times the number of rushees that might be there, 20. That's 2,000 young men a year, perhaps could be made safer by the virtue of those changes. So I think that's an important piece of this puzzle as well.
Absolutely. No, it's incredible. I even had a client who's got a deposition on Thursday in our office earlier today. And I told him, I said, while we were preparing, I said, you know what? Like, you've already won in many respects. You can't screw this up. The city of Richmond main library had these railings that were like the base of them. I mean, you could almost see through them. They were so old and rusted that when our client leaned up against one, he fell a good 6-7 feet, landed on his neck. Terrible, right? Sure. And but just by him bringing this claim and bringing this lawsuit, every single railing has been fixed, right? So, I mean, I think that is the deterrence piece, and the ability to affect a change and make the world a safer place is something that I think we need to remind ourselves of even more so when we do this type of work. But
exactly,
because that's it. And I mean, that's not what you see on the billboards, right? But I think for those who are really serious about doing this work the right way, that's the motivation.
Yeah. You want to talk about focus groups?
Well, before we do that, yes, because the next thing I had on my list was how you guys go about working up cases, and focus groups, I'm sure, kind of fall into that.
Yeah. So I think we're unique in how we work up cases as well. I mean, we have a group here of 8 personal injury attorneys. We have 5 partners, 3 associates. And I'll tell you that most of us are involved in every case that we get at some level. So we do staff our cases pretty heavily with attorneys. There's somewhat of a divide between people who are going to focus on damages and people who are going to focus on liability. So that divide kind of stays usually throughout a case. I mean, when I work with Pete on a case, usually we're working on damages together, but it'll just depend on the type of case. But we have a lot of people involved in our cases. I mean, from the beginning, we go far and wide with our FOIAs, with our investigations, hiring investigators. We very seriously want our clients to get treatment in cases. I think we're different than other firms in that we're not afraid to get people to the right people to get treatment. And over the years, we've been able to figure out who those people are that'll genuinely and seriously treat the type of injuries that our clients have, whether it's prolonged grief disorder from a wrongful death case or traumatic brain injury. So we're very serious about that. We almost always will produce some sort of documentary about the damages in a case, whether that's a full-on production, where we hire a third party to come in and film everything, or whether we do something ourselves. That's something that we like to do in most of our cases. And we'll also do focus groups in most of our cases, usually before a mediation if we can, to get a sense of the valuation.
Do you guys work with David Broughton? I think you all do, right? With DJB Video?
Yes, we have worked with David Broughton. I think I actually met him for the first time at the VTLA convention in DC. And then soon after that, we started working with him on one of our really big cases, actually, that went to trial. So
he's incredible. So I mean, I'm super biased, but I've seen his work. I've worked with him a few times, and that man is quite a storyteller. So it's very, very impressive. Let's dive into the focus groups a little bit more. What does that look like? Are you doing them in-house? If so, how? And I know, I mean, and a lot of our listeners, they hear this over and over again, focus group, right? But the actual mechanics of doing it can sometimes feel very daunting. And then when you want to outsource, it can get very costly.
Mm-hmm. Yeah, depending on the case, we'll do one of several different types of focus groups. We sometimes hire jury impressions, and we'll do kind of a full-on focus group. They'll help us with everything. Other times we will hire people that can run the tech side and the recruitment side of the focus group, but in-house we'll prepare all the documents and review it ourselves. And sometimes we'll even do a focus group that's totally in-house, whether it's a questionnaire to people, maybe even some of our staff, our people that we know in the community, or whether it's an actual, Zoom or live focus group. It's people that we recruit, doing the best we can, and we produce everything. So I think, the biggest lift in the focus group is writing the script, which we spend so much time on. And it's really a good exercise, I think, because at this point in the case, you probably haven't written out the entire case since the demand. And now, we usually do them closer to mediation or closer to trial. So at this point, you really know your themes in a case. More evidence has come to light, and now you're tying it all together. So just writing the script alone, I think, is valuable to force yourself to sit down and do those sorts of things. It's
like law school, right? Like it's like when you get to that final exam and like, oh, I got this cool outline from so and so you can use, and then you realize I guess I'll go. I'm sure I tried that and it didn't work out well. When you realize that the actual use of an outline is the process of putting the thing together, right?
Yes.
So then that's how you actually learn.
I think that's right. I think we learn from working on the script all together, and it forces us all to crystallize our themes, right? And figure out what's important and summarize our experts' evidence, stuff like that. So we'll draft a script. We really focus on drafting a neutral script, if anything, defense leaning, probably because sometimes we'll even make up defense experts if expert disclosures haven't occurred yet, so that we can give the mock jurors something to consider. So our focus groups, during them, we'll show clips of the damages videos I just talked about, the documentary videos. We even recently did an interesting sort of, it wasn't quite a focus group, but it was, we put together a video presentation of our case. So one of the attorneys kind of gave an introduction to the case. There were photos that were shown in the video, clips of different potential witnesses' testimony. And the way that this company that we hired to do this did it is they showed it to a group of people, and they measured these mock jurors' micro reactions.
Yeah, emotion track, is that it?
Yes, emotion tracked.
I'm familiar with them. I haven't used them yet.
So that was our first, that's kind of here's the thing. We're always interested in doing things different ways. Of course, we like the classic ways. We think they're very valuable. But that's something we tried recently and found the information to be useful. I'll have Pete talk a little bit about how we actually end up using the focus groups, because I know people have a lot of opinions, how to use them one way or the other. Do you use the numbers? Do you just use points on issues? Do you show clips? Should you pull something out at mediation? Should you give it to them before? But I think the first thing I did when I came to this firm was draft a focus group script, which was a really good introduction to what we do here.
So I'd say the focus group is like this, right? How many times have we been doing these for decades? When we get a jury, the focus jury will look at a document or look at a picture, and say, what about that? And we're like, wow, we've been working on this case for 3 years. We think we're reasonably sharp, and we missed that completely. And so you've got to know, particularly with demonstrative exhibits, what they're thinking. Secondly, you see where they get all fouled up on jury instructions. We give them real basic jury instructions, but we see where the pressure points are, where things that are really sort of dangerous for us are. Third, if we do this right, Sharif, we have a summary of all the main points of the focus group in one column. And then in the next column is a to-do list, right? Like, oh, we didn't have a good lay witness from the person's employer. Focus group people complained, let's say, about a lack of that. Well, bam, we get picked up the phone, we talk to our client, we say, give us 5 people that we should interview at your employer or ex-employees, ex-colleagues. That's really helpful in generating a to-do list. The next thing I would say, and Barkley alluded to it, is sometimes we take greatest hits. We videotape them typically on the biggest cases, and we did this in a case we have for mediation tomorrow. We took greatest hits, gave it to the mediator, and said, we want you to know what a focus group in Northern Virginia will think about this case. And in that case, the average focus group verdict was north of $10 million. So we thought that was valuable for the mediator, who's a big-time mediator, to see. So there's so many different ways in which you can use, focus groups. We're just kind of touching on 3 or 4 of them.
We also usually will give information to each group of mock jurors. So in a focus group, we might have group A, B, and C, right? A gets a different verdict form than group B, and C gets a piece of information that A and B didn't. And so that's really been helpful in testing specific sorts of things. And I mean, jury instructions, figuring out which ones are clear, where the jurors are getting hung up. And I think verdict forms are so important after having a first jury trial in October of 2024, learning that the jury was a bit confused by our interest, the interest portion of our juror form. I mean, that's so critical, right?
It is. It's the one sheet that they fill out. It's the worksheet, right? Like, how in the world do you not talk about the verdict form in opening potentially? Maybe even it's certainly in closing, right? Like, you're 100% right.
Yeah, maybe we should focus group, like micro focus group, just the verdict form. Once we have that prepared, because it's
what I started
critical.
doing is I took, how a lot of people use the word like award. I took I don't like that award because it's not an award. Nobody gets hurt at no fault of their own and then gets an award. That's not awards when your 4-year-old wins a soccer trophy or something like that, right? So I take the bottom of jury instruction 9.0, which says it's like the 2 lines where it's like, I should know this off the top of my head, but like you compensate for the full and fair value of defendant's negligence. I make that the first line of the verdict form. So anyways, I agree with you. And we should, if you ever do decide to focus group a verdict form, let me watch. I'd love to. It'd be fantastic. So
let me mention one more thing that Barkley just spurred me to think about. So occasionally Sharif will focus on one issue. So we had a big case in federal court. And as you know, or may know, there's a real uncertainty as to whether in the Eastern District you can use the addendum, right? As anybody knows, state court, we can mention the addendum, hugely advantageous to us. So we didn't know whether or not a judge would let us mention the addendum. So we did focus groups in the exact same script. The only exception was one group got the addendum, the other didn't. It made a $5 million difference in their award, in their verdict, I should say, which was remarkable. So we knew we had to fight like hell to make sure we could try to get the addendum, before the jury.
Well, I mean, the anchoring principles are so powerful, so powerful. And also, I mean, now we're talking about the psychology of jury persuasion, and like, that's why this work is just so much fun. So one thing Pete, that I want, this has been great, by the way. Like, I feel like we have just gotten started. But one thing I do want to talk about, which I know is very, very relevant in the cases that your firm works on, and you talked about it earlier before we got on the episode, was the institutional betrayal and how that is a consistent theme in your cases. Can you share a little bit more about that?
I really would like to, because I feel very deeply about that. So this is what helps motivate us, in part, institutional or organizational betrayal. And what does that mean? It means when a trusted institution, a school, a hospital, a university, a church, fails to protect someone from harm, first, second, covers up the harm, and third, and/or responds inadequately after injury or abuse occurs, thereby betraying the trust. And this happens, and Sharif, when you have a sexual assault of a young woman, for example, you have mental health damages from what happened, but also separately from the betrayal. And this often occurs with the most vulnerable populations, children, severely autistic adults. We have a case involving an autistic adult right now. Young women in a university or college setting, caretaking, pastoral counseling, high schools, sports organizations, you name it. But the issue is where the bond between the institution and the person is strong, and there's a big power differential due to the size and strength of the institution. Let me give you one example I keep coming back to. We represented a young, very naive 18-year-old girl who left her rural community for a big city university. Immediately upon starting school, a chaplain, what turned out was a perpetrator, he started grooming her very, very intentionally in a series of course, escalating ways. Eventually, he lured her to his apartment, and he sexually abused her in terrible ways. Two remarkably courageous upperclassmen, a woman and a man, found out about this horrible example of sexual assault, sexual abuse. They reported it to a bishop on the church side and a high-up university employee on the university side. And the school and the church did nothing. What did that do? You know what it did. It green-lighted him to do it all over again, brutally sexually assaulting her over a series of weeks, as a result of which, obviously betrayed, she tried to commit suicide. So that is a front and center, terrible example of what happened in this situation where there was brutal institutional betrayal.
It's incredibly sad to even know that that stuff happens, right? And then I find it, I don't know what the right word is, but egregious is the wrong word. But then you get into these cases, and as hard as the defense will fight, right? Like, despite the horrific acts, right? And the betrayal, it's truly incredible. I mean, I guess it's job security for us, but no, this line of work is certainly not an easy one. And I think our clients, and I agree with you, yes, they suffered harm, but even more so is that loss of trust, right? And we a few of those cases ourselves. So, Barkley, please.
Yeah, and we've learned that this type of betrayal trauma can compound the development of post-traumatic stress disorder. There's even a causative link between high institutional betrayal and disassociation. We also know that sometimes what follows these sorts of events is a victim's enmeshment with either the perpetrator or the organization. Perhaps, delayed recognition of what actually happened, sometimes decades. So they're really interesting, sad cases that happen now in a variety of different contexts because we have so many communities that we're all involved in, organizations that we're a part of, that we have such such trust in. The case that Pete's talking about was one of the first really big cases that I worked on here. And it was a academic lesson in psychology for sure, working with the experts that we had in that case and being introduced to these sorts of topics.
And there's a lot of lawyers who actually don't even see the value in these cases. And we recently took on a case where a lady whose nonverbal autistic son was abused at a residential center, and we weren't the first call. Other lawyers didn't think it was a case, and it's sad. I mean, it's more than a case; it's settling for quite a bit. But it's a blessing that we have people like you guys who are not only doing cases your own way, but also kind of leading the example here in Virginia for these victim-led cases. So thank you. Before we close up, though, Pete, I'd love to ask you this question. We ask it of a lot of our guests. And Barkley, feel free to answer it as well. It's been 3 years, but it's probably been a fire hose working with Pete and the team that you guys have. But Pete, if you could go back to when you first started practicing law and give yourself some advice, what would it be?
Well, I'm gonna give myself advice as a trial lawyer because I had a different incarnation that I don't think would be that relevant. Okay?
Well, that type, I did that stuff too, and it doesn't count. So
right, exactly. Going out of UVA, you go corporate, right?
That's right.
So I would say, well, I'm going to slightly change the question. I would say never leave a jury that is deliberating. Okay, and let me tell you why I say that. I tried a crime victim case in California, 30 days total, 13 trial days. We were exhausted. The jury went out. The jury was deliberating, and the jury had to answer 7 questions for us to win, 6 or 7 questions. They answered 3 questions. We won. Then it was a matter of how much it was going to be. Then a juror got sick. That juror was replaced by a juror from hell. You could then hear people screaming in the jury room if you were out in the hall. And the jury went back to square one and resulted in a defense verdict. Well, at some point, I was exhausted. So I left, and I left my co-counsel, their firm, to babysit the jury. I hate to admit this, Sharif, but I talked to one of the jurors. This happened about 25 years ago. And she said, "Where were you? Why weren't you in the hall? Why didn't we see you when we came out of deliberations?" And I'm like, God. So it may seem like a simple thing, but don't ever, it's your jury. Don't ever leave them. That I will never forget as long as I practice.
Thank you, Pete. Barkley, how about you?
Yeah, I was kind of thinking of some advice I have for young attorneys. And I think the most important thing at this stage in our careers is, it's simple, but it's who you're working with. So who your mentors are. A lot of professions, you'll come out of school, or in school, maybe you're placed in a position where you're really learning on the job, like in medicine, right? But in law school, you go to law school, then you graduate, and you don't really know anything. And then you need to learn everything. And you are entirely relying on the busy partners to give you their billable time, their knowledge, to teach you, to lead you. So I feel very fortunate to be in the position that I'm in at Blankenship and Keith, because I've got 5 partners who give all their time to me and bring me in on all sorts of cases, and more than that too. Everyone at this firm. But if you don't have that at your firm, I would encourage you to go out and seek it. Regardless of even what kind of work you're doing. If you've got that, that's significant. If you have people who are willing to lead you. So that's a piece of advice I have, as well as people my age do not like to talk on the phone. So I would say make phone calls. Better yet, go in person to places right away. Just do it. Get used to it. And it's amazing what things you'll find out if you get someone on a phone call, what people will tell you or say to you. I think it says something about your investment in a case and what kind of an attorney you are as a young attorney who's going to be on top of it, make the phone call, go places in person, and not just be behind a screen or behind an email. I'm always impressed when someone my age calls me right away instead of sending a scripted email. So it's not something that people who are millennials are used to, and I think it may even be getting worse. But if you can do that, you're going to get a lot of information you wouldn't otherwise.
No, absolutely. Absolutely. Well, guys, it's been a real pleasure having you guys on the podcast. I hope we get to meet in person here soon.
Sharif, I want to thank you for being involved in the National Crime Victim Bar Association. I think it's a remarkable institution. I'm so glad to have, there's so few other Virginians in it. Barkley's in it, I'm in it, maybe one other person from our firm. There's only a handful of people, Kevin, but not many across the Commonwealth. So I'm really glad you're involved in that organization.
Well, thank you. And in full candor, you're the reason I am involved. So I'm truly indebted to that short phone call you had with me a few years ago has made a world of a difference. So thank you. And I look forward to staying in touch, and I'm sure we'll meet up here soon.
Sharif, okay. I just want to say before we end that I am an avid listener of the podcast, and I don't even know how I found out about it initially, but I mean, it is within my top 3 podcasts that I listen to every day, and I listen to a lot. So your voice is very familiar to me from all my runs and my workouts where I'm listening. And it's been, that's another piece of advice I have. Listen to this podcast, because I've been able to hear about so many different people and hear stories from so many different people, and it's really helpful. So,
well, thank you.
Thanks.
As I told you guys earlier, it's not because of me or my friend Niall. It's because of people like you guys who are guests. So it's been a lot of fun doing this. We're learning a lot, and so we'll keep it going. And to have you guys on has been a real privilege. But thank you.
Thank you so much.
Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.